Legal problem solving is an essential skill for the study and practice of law. There are a number of legal problem solving models, with the most popular being IRAC, and today we are going to provide an introduction to legal analysis using the IRAC method. Now, IRAC is a method of organising within analysis, and it is firmly established as the prescribed method of analysis for law globally. The IRAC methodology is useful to help you organise your legal analysis so that the reader can follow your argument. It is particularly helpful in writing exam answers and legal memos. This allows your reader, whether that be a law professor, a judge, or an attorney, to systematically address your analysis for every legal issue that you have prescribed. IRAC is an acronym, and it stands for Issue, Rule or Rules, Analysis, also sometimes termed Application, and Conclusion. Issue is the legal issue or legal matter at hand. The rules are applicable to this issue, and we use the analysis section to explain the relevant laws and case law as they apply to the facts. We then move on to the conclusion, which provides a conclusion or summary of your legal analysis. So the issue. Before we can find the issue, we need to read and understand the facts of the case clearly. We need to know who are the parties, what happened which led to this dispute, where is the dispute to be heard? In other words, what is the jurisdiction that this case is in, which is relevant to decide what type of law or legislation we can rely on. When did this dispute occur? This is relevant for limitation of liability periods. We then need to ask, do we have all the facts? Is there any information missing? If there are assumptions that you are making, you need to state them very clearly. If you have legally relevant, unanswered questions, you might have to make certain assumptions within your analysis. We then need to state the issues succinctly. This can be in the form of a question or a statement, but should be specific rather than too broad or general. An issue should be broken down into smaller, multiple sub-issues, with IRAC reasoning applied to each sub-issue if this is applicable. So some tips for your issue section. An assignment usually covers one area of law. For example, if you are in a contracts course, your issue will be something to do with contracts. Equally, if you are in a torts course, your issue will be something to do with torts. But they may involve more than one issue within that area. You need to use the IRAC structure for each issue or legal topic in the problem, and issues may emerge gradually as a result of your research and identification of applicable rules. We then move on to the rules section of IRAC. Now, legal rules consist of the primary sources of law, which is legislation or case law. And if you are unfamiliar with the area of law involved, these can be identified using secondary sources. For example, you might look into legal dictionaries or encyclopedias, textbooks and legal commentaries relevant to that specific area of law. You might also want to refer to your class notes and your reading guide to help point you in the right direction. Once you understand the area of law involved, you can begin researching the applicable legislation and case law to assist with your IRAC response. As a rule, criminal law cases will need a reference to a statute or a piece of legislation. Many civil law cases may not have an appropriate statute. In this instance, you will need to rely solely on case law and ensure that you cite your legislation and case law appropriately. Now, we need to break down the relevant rules of law into elements, and each element is a sub-issue to which you will need to apply the IRAC reasoning. You need to ensure you are using law which is applicable for your case's jurisdiction, and the legal principles should be stated with both precision and accuracy. Always support your legal principles with authorities and reference these accordingly. Ensure you are confident to research and find authorities using relevant legal databases, And please note that primary sources should always be used as the rule. However, secondary sources may help you understand the issue. So primary sources include bills, acts of parliament, regulations, law reports, and judgments. In contrast, secondary sources include textbooks, legal dictionaries, journal articles, and commentary. Please do not use your textbook or your lecture slide as a reference for a rule. These are not legal authority. If you are struggling to find primary legal resources, on the screen is a brief list of where you may start your search. Equally, a brief list of where you may find your secondary legal sources. So analysis. This is where we apply the rules to the facts of the problem or issue. So we take the issue, we take our rules, and now we apply them both in the analysis. This is where we discuss our relevant evidence and explain how the rules apply to the facts. Here we need to use relevant cases, legislation, and statements of legal principles to support our answer. We focus here on any contentious issues or areas where we may have assumed facts. You may need to answer and argue both ways. We need to also assess the strength of the law for your facts. If it is very applicable because the facts are very similar to the precedent, that would be strong. It then goes down to good, weak, or poor. By including this assessment, you show your assessor or the judge or your attorney that you understand how that case law applies in light of your facts. So some tips for the analysis section. This is the most important and generally also the longest segment of your IRAC response. Where appropriate, argue both sides of the case and anticipate counter arguments and defenses. Reading judges' reasoning in cases can help you understand how legal problems are analysed and applied to the specific facts of a case. Use legal principles and precedents in each analysis. Show the reader why this is authority. Do not use textbooks, lecture slides, etc. as authority for your analysis. We then reach the conclusion. The conclusion is where you place your answer to the issue. There is usually no right answer in real life, as this will be determined by a judge. What is important is the process of legal reasoning that leads to your conclusion. For university assignments, the facts will generally have been worded in such a way as to lead students to a right or preferred answer. Try to reach a convincing conclusion on all of the legal issues in the factual problem based on strong support from case law and legislation. The key thing here is that you must come to a conclusion based on the evidence. You need to choose or select the argument that you think is the strongest and articulate what you believe to be the appropriate legal advice. Use terminology which supports the likelihood of a particular outcome, such as this is likely to lead to X, Y, or Z. Thank you for listening, and if you have any questions or would like me to create any more IRAC videos, please let me know in the comments.